On 2nd October 2010, the body of 16-year-old Neesa Gopaul was found inside a suitcase which was submerged in a creek near the Linden-Soosdijk Highway. Her mother, Bibi Gopaul, and the mother's lover, Jarvis Small, were charged with murder under Section 100 of the Criminal Law Offences Act. Small's attorney applied for separate trials, but this was refused by the trial judge. At the close of the prosecution's case, Small's attorney submitted that there was no case for him to answer, but this application too was refused by the trial judge. The jury returned guilty verdicts, and the trial judge imposed sentences of 106 years and 96 years imprisonment for Gopaul and Small, respectively. They appealed separately to the Court of Appeal, and that court upheld their convictions, but reduced their sentences to 45 years. Gopaul and Small filed separate notices of appeal to this court against their conviction and sentence. This court consolidated the appeals. The judgment of the court was delivered in two parts by Justices Jamadar and myself. The court separately reviewed the evidence against the appellants. In relation to Small, there were three matters of evidence: reports that he sexually assaulted Neesa, a pair of dumbbells which were found with the suitcase in which Neesa's body was found, and a statement by Small that he did not murder Neesa, but he knew who did. This court rejected the state's argument that the reports of sexual assault provided motive, as it was pure speculation that Small had the motive to kill Neesa to avoid prosecution for sexual assault. The court found there was no evidence that Small had retained possession of the dumbbells to have placed them with the body. In relation to Small's statement of knowledge of the identity of the murderer, the court found that it was impossible to conclude that because Small said he knew about the killing, that he was the killer. As these were the only matters of evidence against Small, the court was satisfied that the trial judge should have upheld the submission, that there was no case for Small to answer, and directed his acquittal. The paucity of evidence against Small would have been apparent at the beginning of the trial, when the application was made by Small for a separate trial, and when it was clear that evidence of a confession that Gopaul had made to a cellmate was inadmissible against Small and would be highly prejudicial to him. This made it an exceptional case where the trial judge ought to have directed that there would be separate trials. Small was gravely prejudiced by the joint trial because he was convicted on the strength of evidence which was completely inadmissible against him. In relation to Gopaul, the testimony of Simone de Nobrega, who was at the time awaiting trial for offenses relating to obtaining credit by false pretense, was that she met Gopaul in the lockups, and Gopaul confessed her and Small's role in Neesa's murder. As this court strongly stated, this evidence should not have been placed before a jury trying the case against Small. The court was also careful to state that it was a question for the jury whether they believed de Nobrega was truthful in telling them what Gopaul told her, and also how much of the story told they believed. The evidence given by de Nobrega was that while in the lockups with Gopaul, the latter told de Nobrega that she, Gopaul, and Small had an extramarital affair, and Small eventually encouraged Gopaul to kill her husband, which she did by poisoning him. Neesa, the daughter who was later murdered, found out about the poisoning and made a report to the police, and later talked of pursuing the report, and this led Small and Gopaul to make plans to get rid of her. On the day of the murder, Gopaul was driving her two daughters and Small in a car on the Linden Highway. While the younger daughter was sleeping, Small began strangling Neesa in the car. Gopaul then stopped the car in a trail. Small then dragged Neesa out of the car and bludgeoned her on the head with a piece of wood. He then put Neesa's body into the trunk and they left the scene of the crime. The body was left overnight in the car at Gopaul's home. Gopaul said that on the advice of Small, she took from her home personal items that belonged to Neesa, such as her bank book, passport, and Muslim robe, to make it look like Neesa had run away. She and Small also took a pair of dumbbells that Small had given her and a length of decorative rope to attach the weights to the suitcase in which they would place the body to keep it submerged. They returned to the scene of the murder on the following day and placed the body in a suitcase with the personal items, then submerged the suitcase into a creek by weighing it down with a dumbbell and rope. The court rejected counsel's argument that the jury was not adequately warned about the danger of acting on the Nobriga's testimony, and that this rendered the conviction unsafe, as there was no other material evidence connecting Gopaul to the murder. The court rejected the argument that there was no material evidence connecting Gopaul to the murder and pointed to the items found with the body that a jury could reasonably find came from Gopaul's home and were provided by her. The court found that the trial judge delivered an adequate warning, and the jury would have clearly gotten the sense that he was telling them to be careful in deciding whether to believe the witness. Counsel argued also that the trial judge failed to warn the jury of the prejudicial nature of the part of the Nobriga's testimony concerning Gopaul's poisoning her husband. The court found no reason to interfere with the Court of Appeal's finding that though the trial judge failed to warn the jury not to use the alleged poisoning of Gopaul's husband as proof of guilt of this crime, no substantial miscarriage of justice had thereby been caused. Justice Damada delivered the decision of the court on the issue of sentencing. Gopaul was subject to sentencing according to Section 100A, sub 1, paragraph B of the Criminal Law Offences Act, which prescribes that a person should be sentenced to imprisonment for life or such other term as the court considers appropriate, not being less than 15 years. The court found that in this case, there had been no fair and just sentencing process. The sentence imposed by the trial court, 106 years, with a starting point of 60 years, exceeded the life expectancy of a human being and was grossly disproportionate and manifestly excessive. The sentence and the manner in which the trial court went about it were contrary to Section 144, to the Section 144 constitutional guarantee of a fair hearing by an independent and impartial court, and to Section 141, as the disproportionate and excessive penalty imposed was tantamount to inhuman and degrading punishment. The resentencing by the Court of Appeal was also reviewed. This court noted that the Court of Appeal did not discount pretrial custody in accordance with this court's guidance in the Costa Hall against the Queen. The court considered that the sentence itself of 45 years, though not as grossly disproportionate as the trial judge's sentence, was still manifestly excessive, and the Court of Appeal did not indicate the period of ineligibility for parole consistent with the legislative intent in Section 100A, subsection 3 of the Criminal Law Offences Act. This court considered local cases which were cited, which did not include murder of minors, focusing on the inherent aggravating and mitigating factors relative to the offense and not the offender, and determined that a reasonable generic starting range was 15 to 20 years imprisonment. There was justification for choosing a starting point at the higher end because the case involved the murder of a minor. Further, there were unique aggravating factors in that it was the murder of a child by her parent, which was associated with the vulnerability of a minor, the betrayal of trust and responsibility by a parent, and the degree of violence used to commit the offense, including the wanton disregard for the personhood of the minor. As such, the court found that there were good reasons to increase the upper limit of the starting range to 22 years and to select a starting point at the upper end of the new range. The court then identified the following considerations which would justify a stage 2 uplift relative to the commission of this particular offense. 1, there was a special relationship of trust and responsibility. 2, the degree of blunt force to the head. 3, the method of disposal of the body. And 4, the lack of any remorse by Gopaul and any evidence of motivation to murder her child. The court also considered that it had appeared from the record that Gopaul had no prior convictions and she was at the time of sentencing undergoing rehabilitation. The court termed these as potentially mitigating circumstances. The court also considered as a special circumstance the public interest in the welfare and protection of minors. Having regard to all these factors, an uplift of between 5 to 8 years was justified. The court found that a fair and just sentence of imprisonment for a term of 30 years with parole eligibility not before 15 years would meet the penological objectives of sentencing. From that sentence, the period of 5 years would be deducted for time spent in pretrial custody. In a dissenting judgment, Justice Smith opined that both the convictions of Small and Gopaul were unsafe due to the lack of quality evidence. Justice Smith did not agree with the majority that the personal items found with Neesa's body were tantamount to the strength of fingerprints. In his opinion, it was a stretch to conclude that the personal items materially connected Gopaul to the disposal of Neesa's body, and even more so, the actual murder. The Nobraga's evidence was the only substantial evidence, but that could not have been safely used by the jury. Data unearthed by many studies show that the evidence from a prisoner awaiting trial, a quote-unquote jailhouse snitch, was unreliable. The warning given by the trial judge in the present case was inadequate and far from robust, and the jury could not have been effectively educated on the dangers of the evidence. Additionally, the Nobraga's evidence was substantially uncorroborated and unnecessarily so, as there were serious investigative flaws. The other supporting evidence was weak or equivocal. In a postscript, the judge also made some critical remarks about the, quote, universal rule that the use of an out-of-court admission against a co-accused would always and in all circumstances be unfair. In summary, the court allowed the appeal against conviction and sentence of Jarvis Small, and it dismissed the appeal of Bibi Gopaul against conviction. Her appeal against sentence was allowed in part. The court substituted a term of 30 years imprisonment with no eligibility for parole before the expiration of 15 years. From this sentence, the period of 5 years will be deducted for time spent in custody while on remand. That is the summary. Thank you, President.